Dice, you broadcasting. Bien. Hello. A ver qué pasa con el sonido.
No, hombre. Se sorprendían cómo le da la vuelta al papel.
Dice que no me ven, pero ahí estoy.
Oh, I see her now. If she has technical problems, their advice is always use Chrome or Firefox. Pero...
Estoy en Firefox. No, estoy en Chrome.
¿Sí?
Yo creo que estoy en Chrome. Ahí estoy, live chat. ¿Me puedes ayudar a ver qué pasa? Porque dice mi micrófono está activado. Hello.
Can you help me see what is happening? Because my microphone is approved. Who's printing something? Oh, you are. Okay, you're printing the draft? Okay, well, maybe we can do that later? I can't hear anything. Can someone help me? Hello? What should I do now?
What could we change? And I am trying in Spanish. Puedes poner en el tuyo si se oye.
Pero que solo escuchabas a los, escuchas a los otros. No.
Can you check if you can hear me in Spanish?
Está acá.
Disculpe.
It's a test, just to see if you... Hi, everyone. Good. Okay, you can see me. Can you hear me? Yeah. Okay, so Ana Maria, I think it's fine if you can... yeah. Okay, so I think it's fine, Ana Maria, that you can't hear us. So it's just when you give me the floor that you can hear me, right? Okay. Now you can get the floor back, Ana Maria, I think, and start. I think it's the whole purpose of this software is that not everyone can take the floor without you having to accept it. Okay, now if I look at the board with the presenters, it says that Ana Maria is offline. Is it possible? From you. I wanted to try to see if people are hearing something and you could hear us. But now I think you have to take it back. I mean, I can run the show and say something, but I think people are looking forward to hear all the other presenters and the introduction. No. To Daniel, no, we don't hear. I mean, at least I cannot hear anything. I mean, I can hear myself because I've got the floor right now, but you have to take it back so that we can hear Anna. I'm not hearing her.
Ahora, me escribes.
Hola. Ok, parece que ahora me pueden escuchar. Siento mucho los inconvenientes técnicos. Y vamos a empezar con una corta introducción sobre, bueno, la idea de este webinar es que empecemos, o de este seminario en línea, es que podamos presentar algunos de los análisis que hemos hecho sobre diferentes temas que hemos identificado como de especial interés para las organizaciones miembros de la Alianza por el Tratado. La metodología será que empecemos con una pequeña introducción de 3 minutos para el primer tema, que es el tema del alcance de aplicación. Tenemos 2 personas dando sus introducciones, ya que este es uno de los temas en los que tenemos más, parece que no hay traducción, así que ahora lo diré en inglés, en los que tenemos más diferencias y por eso hemos invitado tanto a Magdalena como a Gonzalo. So it seems to be that there is a problem with the translation. I was just explaining that we will have 5.
Hi, good morning. The reason why we invited Magdalena and Gonzalo is because there are a couple of points that we have disagreements on.
And then to have like 10 minutes for discussion per topic. Therefore, I will be quite strict with the time. And for the first topic, the one on scope, which is one of the most discussed ones among us, we will have 2 inputs. The first from Magdalena from FIDH, and then we will have one from Gonzalo from TNI. So I will give the word to Magdalena. Magdalena, you can go ahead. Magda, you have now the word, the floor.
Hear me? Yes, okay, I don't know.
Magda, you have now the word.
Good. So, hello everyone. I will try to kind of summarize very briefly what we think about the scope. The scope has always been a very debated question. We think mostly for ideological reason than for real ones. Because from our experience on the ground, what we know is that from one side it's very difficult to give access to justice and to get transnational companies, as we consider them transnational, like the big multinational companies, to respect human rights. On the other side, we also know that is in certain contexts, sometimes many contexts, is very difficult to make access to remedy and justice for corporate abuses available at national level. So we always had this twofold understanding of the current situation, and therefore we have always said that a treaty for us needs to have a sort of, it's good to have a focus on the transnationality of the activities that of course poses some serious problems and challenges that cannot be solved elsewhere in anywhere else, but at the same time the issue of national implementation and of lack of enforcement mechanism and of lack of justice in national level cannot be neglected. So we think at the same time that the proposal of Ecuador, starting with the elements and now with the current draft, could be an option to overcome these impasses and particularly focusing on transnational activities. At the same time, the risk, in our perspective, is the one of definition, because as soon as we need to define certain terms, such as transnational companies, that doesn't really exist in legal terms, or also, as we see in the current draft, we will need to define what a transnational activity is. Then we run the risk to create loopholes and to create situations where companies can fall outside of the scope, and also where companies can create structures in order to fall outside of the instrument. So we don't want this instrument to create those situations. And we would like the scope, that's why we would like the scope to be the larger possible. We remind the fact that we understand and we know that there are issues linked to the transnationality of the activities that needs to be addressed by an international instrument. So just to conclude, for example, one concrete example that came in our mind when we read the current draft is that, for example, an activity of a company that is situated in a jurisdiction, let's say in France, and that imports some material from, let's say, Africa, Nigeria, and that it doesn't do it directly, but it does through another company that is based in France, and that is this second company that imports the material from Nigeria. Could we say that the first company, the retailers, for example, could we say that it has a transnational activity if it buys the stuff only from the French intermediary? So that are questions that on practical level we need to ask, I said. Yeah, that's all. Thank you. I'm finished. Ah.
Muchas gracias, Magdalena.
Hablo en español.
Thank you very much, Magdalena. Now I would like to give the floor to Gonzalo, who will share the campaign's perspective. So, Gonzalo, please, you have the floor.
No,
Morning, shall I speak in English or Spanish? Spanish is fine. Ana Maria, dear friends, thank you very much for organizing this event. From the campaign's standpoint, we have always had a clear idea about why we need an instrument of this kind. And this is related to the scope of the treaty. We always said that the priority were transnational companies. And the zero draft is not specific about that. It is not specific with regards to transnational activities. We don't think this is a problem. The reason for this is that it will address the issues with regards to transnational companies, and what we think is that it is essential for civil society to follow this train of thought. Why? This is a topic that will definitely be subject to negotiation. Several states are already putting this at the center of the negotiation table, and in that sense, we also need to adopt a standpoint where we focus on negotiation. Therefore, what we need to do is to see negotiation as one of the main aspects of our work, because otherwise we are going to face a lot of difficulties, and we could have problems in the future, because it would seem that we are already yielding to this point, and this point is very strong in negotiation, especially when we address issues with the transnational companies, and that is why we need an international agreement rather than just an adjustment to the national regulatory frameworks. So that is the first point. And the second point is the supply chain, or the value chain. Okay, so time's over. Well, I think that these concepts are not well defined, and the responsibilities between the legal person and the natural person are not well defined, and I think that the definitions need to be clear across the whole chain. And finally, I believe that the treaty should be more categorical on the human rights instruments that need to be taken into consideration. Because if these things are not clear, it becomes a lot more difficult to implement. So thank you very much for your attention. So that was it for my participation. Or should I say something else? Well, you know, I can talk and talk. Well, Anna says that if someone has anything to say about this, please do so. Hi. I just jumped into the discussion, so please, if you want to say anything about this, please tell us in the chat so that we can give you the floor. I'm not sure if there are other important topics to discuss with regards to the scope of the treaty. Do you want to mention any other important points about the treaty?
Denise, just a second. I will Denise, so clear. ¿Y cómo le doy la palabra? ¿Cómo le doy la palabra?
¿Cómo le diste antes?
No, es diferente. Sorry, Denise. Sorry, Denise, but it seems to be that the system doesn't let me let us hear your voice. If you would like to write your question, I will read it, and then we can react. I'm sorry because I hear that there are some problems with the sound, and Lindsay just left. We are sorry. I hope Gabriela would be here to support us with the use of the platform, but it seems to be that she is not able.
Only presenters can speak.
Okay, it says that only presenters can speak, which we were not expecting because it was announced that we have 10 minutes for people to intervene, but maybe you can write your questions here, Denise, and in this sense we could try to have some kind of debate in written way, and I would read the answers. Sorry for this, but I understood that works different. Okay, so if not, I don't know if any one of the speakers would like to add something on different proposals that you have regarding how we could overcome the differences that we have on the scope. Magdalena, I will give you then the word, please. You have.
No, just a small thought that is about the fact that I think there are two aspects in the treaty that we both want to be fixed in some way, and that needs different consideration. And one aspect is the access to remedies. So, for example, the adjudicative aspect, and where indeed the question of jurisdiction and access to different fora is key. But another one is the regulatory aspect. So, is which kind of measures states need to put in place in order to regulate the companies. And in this second part is where I think the problem of a limited scope it would be the greater one, and where would be more interesting to have the instrument posing obligation on states in order to regulate the maximum number of companies possible. I think it rejoins what Denise is writing in the chat to a certain extent. So people, sorry, just look at the chat. If you want to talk, you should disconnect with the button on the left. I think it's the last button of the list, and then you can reconnect using different address like ECRNet guest or ECRNet guest 1 or ECRNet guest 2 or ECRNet guest 3, and they all have the password hashtag human rights with the point at the end.
We are trying, she says, to find a middle ground, especially towards the EU, by saying that a focus on the TNCs is legitimate, but that measures in the treaty should also help to strengthen national justice systems and legislation, and in this way apply also to national activity. I know that other organizations are, for example, proposing a strong clause on consistency in which it's clear that the victims of national companies shouldn't be discriminated with regard to the victims of transnational companies, and others are proposing, for example, to include a clause saying that the articles on liability, due diligence, and rights of the victims are applicable also for the victims of national companies. So these are some of the different proposals that have been presented by different organizations, and in the face-to-face meeting we will be able to analyze better all this. Maybe we can go now to the next point, which is on the jurisdiction, and for that we have somebody from the Treaty Alliance Germany, Caroline Seitz, please. Due diligence and liability, Carlos.
Hola, ¿me escuchan?
Sí.
Hola.
Hello. Can you hear me? Hello? Okay. It seems that yes. So briefly, I'm going to present in 3 minutes the connection that I see between due diligence and liability, criminal and civil in particular, which I think it's problematic, and I think here in the text at least is very nuanced. Yeah, it's not so strong, that connection, which is good, I think, because already under civil liability, as you know, we always look at various elements. One of them is to show that a company or the person who caused harm has acted with negligence. That's not a requirement all the time, no, because there is also civil liability, which we call checked, which means without fault. But the other elements are always required. The fact that the harm is caused and also that the harm exists as well. In certain systems, such as civil law systems, there is the requirement that the action has occurred in violation of a legal requirement, the requirement element of legality. And so negligence is already part of the civil liability scenario. So in that case, I think it's no need to include anything else. If we were to include the requirement of of due diligence as part of the evaluation of negligence, that could be as well, but the risk would be that in certain cases, what will be taken into account is not the fault to the company, which is a very complex element that results for a number of circumstances and factors, but this will be related immediately to a number of steps that are defined in the guiding principles, which are relatively not impossible for any company or anybody to fulfill. So that will basically make it easier for some companies to get away, from what the requisite or the requirement of fault. Now, in terms of criminal liability, the situation is a bit more complicated, because normally in some jurisdictions, such as France, the United States in particular, there is no requirement for the judge or for anybody to look at what the company has done in terms of with negligence or not to find a criminal responsibility. Right? So if we were to introduce that element in this case, I think that would be a major change. We have that element, for instance, in the case of the legislation of Spain, Chile, and Colombia, that basically establish an element of exoneration of criminal responsibility of companies that can demonstrate they have carried out a series of steps. They don't call it due diligence, but they call it compliance elements, right? So I think I think it's the positions that there shouldn't be a so clear connection between the two, in the sense that the civil liability or the legal liability will be dependent and conditional on the fulfillment or not fulfillment of due diligence requirements. Right, so all the other position will be basically to establish the link. That position to establish a link between the two has been proposed by Joe Raggi, and I think it's also advocated by the Office of the High Commissioner for Human Rights in its own proposals, which I particularly don't support in person. So that's my introduction. I think the draft as it is, in fact, doesn't make that link necessarily, so which makes I think in principle good, and it should stay that way. Thanks.
gives an overview and let us understand that due diligence cannot be the only way to attribute liability, and especially that we need to also enforce the due diligence clause provision. Is somebody else willing to say something else on due diligence or liability? Bueno.
Yes.
Sí. Sandra, are you willing to say something? I will give you the floor.
Oh, no, creo que no.
Okay. If not, we will try again to see if Sarah's sound is working.
No, I wasn't requesting for the floor for this one. It was for the last one. But then I passed because...
La debida diligencia y sí, ya la podemos escuchar.
De expositores para ver si tu audio se recupera. Mientras tanto, entonces yo
No, it seems that we're having technical difficulties with Sarah's audio. So Sarah, can you log out and log in again to see if we can get your sound back? Meanwhile, I'd like to tell you a couple of things about what we can improve in terms of victims' rights. The article on victims' rights is a very important one, and I dare say that this is the core of this treaty. And we define that there are at least 4 things that we can improve with regards to this article. So, even if the article about definitions as well as other ones, we have already specified that companies should be responsible for the harm that they have caused. This is not well defined in the article about victims' rights, and we believe that it would be better if we specify that the victims have the right to file complaints against transnational companies due to harm caused by the company across its value chain. Additionally, we have included in elements certain topics that we need to include in the other one. So this is, for example, the principle of security and liability, meaning that companies are responsible for the sum of the harm that they have caused. And if the company incurs in harm once again, then claims can be filed in this case, and we also consider that in terms of information, the clause is still very vague. It only says that the victims have access and the right to all necessary information, and we believe that information should include information about the company and the corporate group that caused the harm. In case this information is not available, we should assume that the action took place, in which case the burden of proof would be in favor of the victims. Additionally, cautionary measures should be included in the article about in the article about prevention, because what we know is that if preventive measures are not taken, there is harm that cannot be undone until, or even if a ruling is passed on this and the resolution is ineffective for the victims. And in this sense, we believe we should include the protective remedies in Article 8 or in the article about prevention. I'm not sure if anyone else wants to mention anything about this. If you have any further comments, please write them down on the chat. Well, it seems that there are not any more additional comments about this. So if there aren't any further comments, we would move on to trade and human rights. And here I will give the floor to Leila Hughes from Ciel.
Okay, great. So I'll start off just by saying that the Zero draft has dropped many of the references to trade and investment that we saw in the draft elements. For example, there's no longer a requirement for human rights impact assessment to include the impacts of trade and investment agreements, and there's no affirmation of the primacy of human rights over international trade law and investment agreements. So what the Zero draft does, it does have two references to trade and investment under Article 13, the consistency with international law. 13.6 kind of has two main pieces. The first is that in future trading agreements, parties should make sure that their agreements don't contain any provisions that conflict with the implementation of this convention. And then the second part is that the parties have to ensure upholding human rights in the context of business activities by parties benefiting from such agreements. So the good thing about this provision is that it recognizes that a conflict could exist. But some of the problems are that it only applies to future agreements. It's vague in the sense that whether a provision in a trade agreement conflicts with implementation of the treaty is not always obvious. For example, on one hand, you could argue that any treaty with fair and equitable treatment or indirect expropriation or ISDS has a chilling effect on the government's duty to protect and fulfill human rights. But on the other hand, you could argue that on their face, these provisions and agreements in general don't always conflict with human rights, and it depends on the specific circumstances. So another problem is the reference to implementing this convention, that the party shall not make agreements, trade and investment agreements that contain provisions that conflict with the implementation of this convention. So since the treaty is narrowly focused on a few key issues, would we argue that a government has violated this provision if it was sued by a company that was challenging, for example, an increase in minimum wage standards under ISDS? So like the actual, details are hard to understand. And then, again, also the provision that says ensuring upholding, that the state shall ensure upholding human rights in the context of business activities by parties benefiting from such agreements. Again, that's vague. What do governments actually have to do? And then the final thing is that this is applying to future agreements. So only. And then another question we had was, well, what happens if a party to the treaty does negotiate a future agreement that conflicts with the implementation of the treaty? How does this provision interact with the rules of treaty interpretation under international law? So which says that conflicts are resolved by looking at the obligations that are later in time or that are more specific. So it's a little bit confusing to understand how 13.6 really would work, or how these conflicts would be identified. The second provision is 13.7, and it says that states agree that all existing and future trade agreements shall be interpreted in a way that is least restrictive on their ability to respect and ensure their obligations under the convention. And the least restrictive standard is interesting because on the one hand, it basically allows an economic agreement to conflict with human rights. And in a way, it gives these economic agreements priority. It just says you have to make sure that these economic rights comply with human rights as much as possible. And then in terms of future agreements, this seems to conflict with 13.6, which says there shouldn't be any conflicts. So there's some internal inconsistency. But on the other hand, maybe this provision is better than nothing, because currently under many trade agreements, domestic measures are judged according to whether they are least restrictive on trade. Then I'll just highlight a couple other big problems. As with probably all the provisions in the zero draft, the lack of a meaningful enforcement mechanism is a fundamental problem. But in the context of trade and investment agreements, the absence is particularly stark because it's not really clear how these provisions would actually change the outcome of state-to-state and investor-state dispute settle mechanisms. And there's no specific reference to ISDS in the draft. So we've already had one call on Friday to discuss these issues in more detail, and then we'll have another call right after this call to discuss it. And we've come up with a variety of ideas about potential changes, but my time is over, so I think I'll just leave it at that for now. Right now, Anna.
That, or I would like to point out that we have also heard from different groups that for many of us it's very important that this article includes a mention of the primacy of human rights over commercial interests. What we know that was one of the big debates in the last session. But we also know that there are some questions regarding the rights of workers, because, for example, in the cases of bankruptcy, they already have the priority. So there are some fears that these two, the primacy of human rights and the priority of workers, could get into conflict, and that's something that we should continue speaking about. And maybe another proposal that we have here is the idea of including a clause that says that when the arbitration tribunal's decisions impede that a state meets their obligations under human rights law, the ISDS or similar tribunals should be excluded. But this, of course, is just an idea, and it would be very important to see which would be the outcome of such a clause. Here, Andrea Bem has a question to Leila saying, how could an enforcement mechanism or swing possibility look like? I will give the floor back to Leila to answer to this question. Leila?
Es todo un tema que quizás alguien más se va a abordar, pero
well, I think that's a whole nother topic that somebody else might be covering. But I think that if the treaty had some sort of form of meaningful enforcement, then the idea is that cases where there was a conflict between investment privileges in a trade and investment agreement and human rights obligations, that conflict would be addressed by the mechanism created under this treaty, rather and these types of cases would go there, and then we would see a higher likelihood of both the decision makers and the analysis of the law give more attention to the human rights side of things. But right now what we have is these cases arising in the context of an investor or a state trying to enforce its economic rights, and in those cases.
The floor to Natalie from Corporate Accountability to talk about the issue of corporate capture, which is included in Article 15 on the implementation of the treaty. And I know after Caroline, also Alejandra Scampini from Poder has requested the possibility to speak. Since it seems to be that you are not available, Alejandra, please write down your message if you want. So, Natalie, you have the floor.
Es la forma. Hola, ¿me escuchan? Espero que me puedan escuchar bien. Voy a hablar acerca del artículo.
Okay, can you hear me? Okay, so I hope that you can hear me. So I'm going to speak about Article 15, and for all of us to know, Article 15 of the Zero Draft says the following: in policies and actions pursuant to this convention, parties shall act to protect these policies and actions from commercial and other vested interests of the business sector in accordance with national law. So I want to start the conversation by quickly talking about what this is entailing, and actually this article is entailing the problem that from many years and from the start of the process we had civil society, the global campaign, and many groups of the Treaty Alliance actually had mentioned, and is the issue of corporate influence and corporate capture. And as an overview, I wanted to mention that corporate influence is the main obstacle to build sound and meaningful policies in many different international policy platforms. And examples of that we have then in public health with the WHO and the FCTC, the Framework Convention of Tobacco Control, in which they have been very clear examples of corporate influence and capture of the process, but especially the ways in which the tobacco companies have been trying to really avoid this space from taking steps to protect public health and safety around the world. Then we have the example that probably most of us know, and is in climate change. In regards to international policy for climate change, in the international platform of the United Nations framework on climate change, we had many examples in which the main obstacle had been the influence of corporations, the main obstacle to solve and to really come up with helpful and sound policies that will protect us all and the war against climate change. And then we also have another example in the Convention of Biodiversity, which we are seeing the same. And then in human rights, we have this space as one of the many other spaces, the space of the IGWG. So, and you might be thinking like, well, what are those, like, how can they participate in these spaces if we are trying to regulate with a treaty to hold them accountable? How are they being part of this space? And the way that they are being part is through the ICC and actually through the Organization of Employers. And this is because the International Chamber of Commerce and the International Organization of Employers, who enjoy a special consultation status with the ECOSOC, actually they hold and they represent the interests of many corporations, or which we are actually trying to corporations that we are actually trying to hold accountable for human rights violations, like Shell, Chevron, ExxonMobil, Nestle, Coca-Cola, PepsiCo, Monsanto, among many others. So in this regard, we are seeing that there are many conflicts of interest, and in the draft, conflicts of interest at the moment of having these negotiations of to hold transnational corporations accountable, because we cannot have, as part of the process, as part of the policy making, corporations that are actually, that their interest is completely opposite to having sound policies to protect humanity. So what we are seeing as the global campaign is that actually the article 15.3 of the Zero Draft, it doesn't really respond to the needs to protect and to safeguard human rights against the undue political influence by transnational corporations, because it's again giving the responsibility to national law, and is saying in accordance with national law, which is actually in where we have very big flaws or spaces, loopholes in which we need to fill. And the way to do it, the examples that we have been giving of good and meaningful policy to protect and safeguard these spaces, these political spaces, and in general democracy. One good example is the WHO FCTC, the Framework Convention on Tobacco Control, actually develops a whole article in which gives the responsibility to the international level, so to the convention, and actually to the national law, so to the states, to develop meaningful sound policy that will protect the policy space on human rights from the influence of corporations. And that it means also in policies on human rights in bilateral, regional, multilateral, and other types of trade and investment agreements. So from the proposal, from the global campaign, actually we are asking to have this development within the preamble of the convention, and also to develop a whole article in which there are different recommendations to protect the convention, and that it means to establish implementation of any laws and public policies for accountability of transnational corporations, state agencies to be transparent and accountable with the higher TNCs, to document and disclose the files of contracts and dealings on TNCs, to institute multi-year bans on revolving doors, corporations coming oh, sorry, I know my time is ending, but we have a key developments that we need to have in place at the international space in this convention to protect the convention against the undue influence of corporations. At the same time that we hope that the convention will develop articles for protection at the state level. So I will leave it for there now, and I know that Fernanda or Alejandra are going to intervene. Thank you.
Seguir intercambiando ideas vía email o el sábado en la reunión presencial.
Thank you very much, Natalie. I know that Alejandra wants to participate, however, she is not logged in as a speaker, but we can continue exchanging ideas either through email or on Saturday during our face-to-face meeting with the Alliance. Now we will have a participation about the implementation or the enforceability of the agreement. So Sandra, I will give the floor to you.
Provisions for, I take for granted that everyone can hear me, right? There are basically two articles in the two articles in the main treaty, so in the Zero Draft of the treaty, and it's Article 14 and 15 for enforcement and / monitoring, because it's important to see that there are more provisions actually for monitoring the implementation of the treaty than for really enforcement. And these two articles 14 and 15 are to be read in conjunction with the draft optional that came out after the zero draft. So the Article 14 is really cut and paste literally from the Convention on the Rights of Persons with Disabilities, literally. And so it creates basically the treaty body, the committee that shall monitor the implementation of the treaty by states parties through these mechanisms of reviewing reports of the state parties, and also specifying that the committee has the function as well to understand, to specify the understanding or to interpret the provisions of the treaty. Okay, and in the second half, the optional protocol foresees kind of additional and opt-in procedures for this committee. So, for instance, it spells out individual communications or complaints procedures and some inquiry functions. What is interesting to note here is that this inquiry procedure is in the optional protocol we have for this treaty is linked to the communication procedure, and it's not the same in other optional protocols where the inquiry procedure is different, it's separate and has more power. So that could be addressed actually following the models we had in other optional protocols. Also, what seemed to me interesting to note is that there is no option for an interstate communication procedure, which has been the case for other optional protocols. So there is a kind of state-to-state complaint mechanism. In that case, if we address transnational activities, that could be considered at least to be added. And also in relation to what Ana Maria was mentioning under prevention, precautionary measures, I think it's also interesting to note that there is no mention, as far as I noticed, of the possibility for the committee to order interim measures in the context of the communication or the complaints at the international level under the committee procedures. And that has been done in many other optional protocols, so in that sense it's weaker than the models we had before. So again, it's not stronger, but slightly weaker through some gaps than what we had in other treaty or optional protocols through other treaties. Of course, I have listened to other discussions by colleagues, and some will consider that the system should be strengthened. Some others will be satisfied that the treaty body preserves at least the core function of quasi-judicial mechanisms of the same nature. I think we have to think not only from the content, but also strategically and politically. We can ask ourselves if this is realistic to ask for a judicial body, for instance, like a real court, or that would be unprecedented in that kind of negotiation. Or that would be really much to add to a process that is already quite complicated. But yeah, it's I mean, I guess I understand also very well the arguments in favor of this. And another solution or an alternative could be to have explicit referral to other or existing courts, proper judicial mechanisms at the international level. So very quickly to finish on Article 15, there is the conference of the party that it's interesting to be included, to see that it's included explicitly as it is in the text. It corresponds to the newer model of human rights treaties. For instance, again, it's kind of taken from the Convention on the Rights of Persons with Disabilities, and it's interesting to have it as explicit and asking for a regular meeting of this conference of the parties, so of the state parties, because it gives a proper, more formal forum for amendments and vote of evolving provisions if needed be. And now, again, really finishing on that, the first half of the optional protocol, I didn't mention that yet. It's basically about this national mechanisms or implementation mechanisms. To me, it's a kind of weird mix of national contact points and mechanisms, like we have for the Convention on the Rights of Persons with Disabilities, once again, and the OPCAT, so the optional protocol to the Convention Against Torture that has these national preventive mechanisms. And actually, I don't see, and I think other colleagues have mentioned that I don't see why it is in an optional protocol and not in the text of the treaty itself, which is the case for the for other conventions. So I think that could be also one argument or one improvement to bring, if we have to include a mechanism for national implementation that is anyway a state obligation. If they ratify a treaty, they shall make sure that it is implemented at national level. But if we want to add something explicitly, that should be in the text of the treaty, not in an optional protocol. And I'll stop there. Thank you.
Rápidamente que en cuanto a la jurisdicción, creemos que el hecho de que sea...
Thank you very much, Sandra. I think that your explanation was very clear, and we don't have the possibility of having Sarah Lincoln intervene because she's offline, but I want to mention very briefly that with regards to jurisdiction, the fact that the concept of domicile and the civil liability across the value chain, as well as the mutual cooperation mechanisms, are important steps forward in terms of extraterritorial legal enforcement. However, we believe that Article 5 considers the Spanish definition of jurisdiction, and jurisdiction understood as legal concept, but without the broader definition of the English language. Jurisdiction in English considers the possibility of the states to regulate legal or natural persons under its jurisdiction, even if they are not in their territory. And jurisdiction in terms of the enforcement of a ruling does consider a couple of things in terms of how the ruling will actually be implemented. However, if the treaty and the convention allows it, maybe we need to add a couple of details to the definition of jurisdiction. Other people have talked about the form necessitatis in Article number 5, which talks about the possibility of victims to file complaints in any territory where the transnational company has a presence in order for them to be better protected. So these are a couple of things that we have analyzed in terms of jurisdiction. This is more or less what Sarah wanted to talk about, but she wasn't able to. And now we will have some time to discuss a couple of things that were not included in the draft, or additional comments about what we have already mentioned. We have Jacob Perez. He is an Ecuadorian indigenous leader. He's also a lawyer, and he participated in the Rio Blanco case. He will join us this week, and now that he's here with us, I would like to give the floor to him so that he gives us his comments about the treaty. Good afternoon, everyone. I have closely heard your comments, and I have a couple of concerns. First of all, what we are the considerations. We have talked about the right to free determination, and I think that much as this is a very important thing, I think it would be very important to specify the right to an inquiry and consultation, to previous free and well-informed consultation in order to obtain a consent from the parties concerned. So that I think that is a key issue. And my second comment is that crimes should not prescribe. If these are crimes that are indefeasible or imprescriptible, that is something that we need to take into consideration. And now, another issue is that companies do not operate with the same name in every state. They create subsidiary bodies. And in the case of Rio Blanco, the international name of Funfi is not the one that we know of, but rather the company Ecuador Mining South America. Therefore, there should be regulation with the companies that have direct operations, companies that have subsidiary bodies. Another suggestion is that above all, we put forward and always at the forefront human rights as well as the protection of nature. I believe that someone has already talked about the burden of proof. I think that in terms of collective rights such as the rights of indigenous communities, environmental rights and others, the burden of proof should be different because the people who file the claims are the ones that need to present the proof of omission or action that violated human rights. So now I have another question. What happens with the states that operate not only within their states? For example, we have Petroval, Codeco, who are not only operating within their territory, but whose tentacles extended to other territories. I believe that rather than only talking about TNCs, we should talk about other states, but we would lose sight of the scope of this treaty, which is TNCs. And my final recommendation would be that I didn't understand very well this point, but if TNCs and the state reach agreement and they do so in express violation of these norms, they will be considered non-existent because they are violating the regulatory framework. So now that we are a couple of hours away from the elections in Brazil, I want to mention that back then we said that Lula got to the presidency, but he didn't get to power. So we are in the face of the single supremacy of only a few, and this is a huge challenge because the states are now subordinates of companies, and it's companies who set their own line of work. And in view of this unbelievably Machiavellic action on the part of TNCs, we, the people, are defenseless, and it's us who are the victims. The tragedy and the dead fall on us. So we need to think about a strategy. I confess that this is the first time that I read the zero draft. I am really sorry about this. I knew that there was an important participation from other South African leaders, but in Ecuador we have a very strong paradox in Ecuador, because it seems that our constitution is the best one. However, inside we have a very strong extractivist activity. So I hope that this campaign becomes twice as strong. And we wouldn't only support this as Ecuadorians, but also as the Kaoi people, to see how we can move this forward. Thank you very much. And thank you very much. Jakub Perez from CAUI. CAUI is the Ecuadorian Indigenous Organization, and it also represents the indigenous peoples of the Andes. I'm not sure if any of the people who are logged in as speakers want to answer any of the questions that Jakub has, or if you think that the zero draft missed out on a specific topic, please mention that. So, aquí Morita says, as for the Article 9, does business activities, including the activities of subsidiaries and that of entities on its direct or indirect control, or directly linked to its operations, products, or services, include, well, this is related to Jakob's question. He also says, so mere purchasing goods and services by transnational corporations from unrelated local suppliers be considered? Would this be considered? Because they are normally not considered as part of TNC activities. And they may not be covered under the new treaty, although huge imbalance of power exists between local suppliers and transnational purchasers. And in many cases, this leads to a lot of abuse in terms of human rights. I believe that this is very important, and the treaty talks not only about the need to be part of the value chain, but also if there is a contractual relation between the companies who we are accusing of causing harm, maybe we can discuss this a little further. And I also want to answer to Jakob's question about the prescription of the crimes. And it is very clear in Article 6 that violations to the international human rights framework would not prescribe. So what you're asking would be applicable to those crimes who are considered such as part of the international regular framework, and that additionally they should not be restrictive, and an adequate time frame should be taken into consideration in order to determine to what extent rights were violated beyond a country's frontiers. So on the one hand, we would be able to bring down the time barriers that sometimes affect people and who prevent them from being able to press charges against TNCs who caused harm. I think this is something that we can discuss in person, but I'm not sure if someone thinks that there is another topic that we have not yet discussed, and it's 29 of us today in this session. I'm not sure if Gonzalo or Carlos or maybe Sandra want to share anything else with us. Okay, so Gonzalo, I will give the floor to you. The interpreter apologizes, the speaker cannot be heard. Sorry, my mic was on mute. I'm going to give a general political interpretation about what we are facing from civil society organizations. I believe that at present Gallegos has been strongly pressed by the European Union, and there are others who say that the time is not right for negotiation, but I believe that we need to fulfill our role in this negotiation. We need to ask for a lot. We need to have very strong demands. We need to have very strong demands in order to make this treaty work. What this means is that we cannot sit at the negotiation table by betting low. And I believe that this is what I have heard. Trying to bring together stakeholders in this negotiation is something that the chair needs to do, meaning the government of Ecuador. And the government of Ecuador is already yielding to others. So, if we yield to others before they ask for anything, I believe that this is an absolutely mistaken negotiation strategy. That is why I ask the members of the Treaty Alliance not to lower their scope, so to speak. Do not lower the scope of your demands, because doubtless that scope will be brought down by Gallegos and the organizations who are against this treaty. If we do this, the only thing that we will be able to do is to sell our standpoint at a very low cost. We know that we need to sell our standpoint, but we need to have a very strong one in the beginning in order for the outcome to be as close to our ideals and to our expectations about the ideal treaty as possible. Thank you. Thank you very much, Gonzalo, for explaining this. Without a doubt, this is a very difficult point, and so I am going to give the floor to Carlos so that he comments on what you said. Thank you very much. First of all, I want to say that I absolutely agree with Gonzalo. For once, we agree. And there is a lot of pressure, and perhaps one of the strategic mistakes from Gallegos has been that he has yielded a lot from the first draft. He has yielded to a great extent. However, the project is still very ambitious. It is the responsibility of the organizations who are here today and others to continue pushing for these requests, and we should not yield to the best possible extent. And the second comment is that I just heard that the states gathered to analyze the working plan, and there is a lot of pressure for negotiations not to take place now. Last week, several organizations and the delegation of Brazil and many others said that it is possible for there to be a lot of pressure to prevent negotiations and for there to be just a general discussion. We'll see how it goes, But we need to be prepared. We need to be prepared so that these discussions about the content of the treaty and the articles of the treaty are not as limited, because at present the majority of the states would rather have a general discussion. So that's what I have to mention. Indeed, Carlos, you are right. It is quite alarming that while we are working on analyzing the content, and as you both said, to have the best possible text, others are working for there not to be negotiation. And in this regard, I would like to know, Gonzalo, as part of the campaign, have you discussed any strategies in case the European Union or other states boycott our objective of starting negotiations? Or do any other organizations have any ideas about this? So I will give you the floor, Gonzalo. The interpreter apologizes. Sorry, I was on mute. So we are discussing that scenario, but to begin with, it has been good to shame the European Union during the first 3 sessions. And right now we already have the resolution from the Parliament, which is a very strong tool to push and to exert pressure on the European Union. However, what's going to happen is that they're going to do their acting, and I think that they're going to yield to a certain extent. I think that negotiations is going to start. We don't think that they are going to boycott the whole session. However, in the beginning, they are going to try to convince us that there are problems with the election of the president. There may also do a little bit of blackmailing with regards to the work that they have already done, but the problem is that if they blackmail us with the issue with the president, that is going to be a very dark thing to do, so to speak. To a certain extent, it would be throwing away everything that has already been done and starting a new era in how the parliament works. So I believe that it's going to be easy to a certain extent to avoid this problem. And Gallegos is going to negotiate the agenda, and we are going to exert pressure on the European Union because they are the most active at boycotting our efforts. And our problem is that Gallegos, in terms of language, is going to create an atmosphere whereby there will be a similar outcome to the previous sessions. And this, to me, is not very positive, and, well, we'll see what happens. I believe that this might happen. Gallegos might yield in return for having the formal presence of the UE during the session. Thank you. Thank you, Gonzalo. It is very clear that this is a very challenging situation, and that is why, as civil society organizations, and regardless of our differences in terms of how the draft has been done, we need to stay together, and we need to have a draft number 1 by the end of this session. I believe that regardless of the work that we do during the week of negotiations, the work that we do at a national level will continue to be extremely important. I agree that it is very important to continue working with the European Union, and as Andrea and Ben said, that it's important to continue our own national line of work, and she says this as an expert at a national level. We know that there is a letter from experts that has been sent to the government, and there is a global campaign working towards having an outcome and a resolution about this issue. And we should also have a very strong standpoint in order to avoid the European Union boycotting the sessions, because if we have a very weak states during the sessions, the European Union will boycott the session and the political game will be uneven. So I would like for us not to leave aside another important party, which is the states that do want to push this forward, but who do not do so because of the political cost. Does anyone else have another comment about the political game, the political strategy? Andrea Bem says, for your information, Attack Germany, together with Medical International, has started a supporting campaign on September 26th to increase the pressure in the German government. We also know that the Alliance for the Treaty in Austria has also been pushing. If no one else has any further comments, we will bring this webinar to an end, even though we have had a lot of technical difficulties in the beginning. We have been able to see and to hear the perspectives of others, not only of the organizations who are constantly engaging in this effort, but also from others such as the indigenous peoples who are directly affected by these activities. So Denise wants to take the floor, and she says that we need to address the issue of human rights defenders. I think that we had left this aside. This is not considered at all within this treaty, even though it is very important. And a gender perspective is very important as well. Feminists have been very clear about their 3 demands in this regard. Gabriela Martins from the ESCR network says that this webinar has been recorded and we will send it to you, as well as to others who could join us. And for those of you who are coming to Geneva on Sunday the 14th, we will have the opportunity to continue exchanging our perspectives and to analyze what our joint strategy will be to keep this process as alive and as strong as possible. Thank you.